Welcome to my channel. So this is the continuation of the previous week's video. Today we will discuss more about international patent. Honestly speaking, there is no something called international patent, but there is a certain way you can apply for patent in other countries, and those are, I believe, is important information for us. Along with that, I will also give more information about the national patents also, which is similar to the align with the last week's video. Okay, so I will start with some more information on national patent rather than international, going to international. So I will discuss in the next slide. So there is, first of all, we need to understand that, as a piece of information, you should know that there is a different price structure for different applicant. If you are an individual applicant, then it will be different. If you are a startup, then it will be different. If you are a SME, that means small and medium enterprise, then it will be different, etc., etc. And the prices and all for application the specific amount, these can be found in the website, but there is a difference in that, so it is good to know that. Along with that, we also need to know that there is something called renewal fee. That means it's not after you are granted the patent, it's not that the job is done, so you have to renew it. First 2 year, at least in India, first 2 year you don't have to pay, but after first 2 year you have to pay a certain amount of renewal fee, and you can pay yearly basis or you can pay upfront for maybe total 20 years, who knows. But I believe as an university professors, if you're a university professor, then of course these will be done by the university, because that is, the university owns the patent. So it's good to know that, but it's strange. I wonder why there is something called renewal fee, because it's already published. Is there any maintenance fee that, or maintenance cost for the patent office? I don't know, but anyway, it's good to know. And another question that we all have is, maybe as an individual, we are filing a patent, which can be which is obviously possible. Then the question is whether we should go to a patent agent for that or not. And I think it is up to you. Actually, it is not necessary, but patent agent can make your task very easy, because patent is a techno-legal document. So technical aspect, we as a researcher, from whatever background, technical aspect, you know that you in your field, you know the technical aspect, so you will be able to write your document technically, but legal aspect may not be that easy. So in that case, patent agents are really good option, but it can be, price can be high. I'm not really sure. So in that case, you may want to go on your own. So importance is not necessary. And other important informations are like whether it is mandatory to obtain prior information from the patent office, Indian patent office, to file application for patent outside India or abroad. Ordinarily, under the following circumstances, it is not necessary to obtain priority permission from the patent office to file patent application abroad. Applicant is not Indian resident and invention is originated abroad. If the applicant is Indian resident and filed patent application has been in India before filing the application outside India, and 6 weeks prior to period is over from that date. So that is the second provision. And the invention doesn't belong to atomic energy and defense purpose. And there are certain some circumstances it is necessary to obtain a priori permission from the patent office, and those are applicant or inventor is Indian resident, applicant doesn't wish to file patent application in India prior to filing outside India. If applicant is Indian resident, a patent application has been filed in India and 6 weeks period is not yet over from that date. The invention relates to atomic energy and defense purpose. However, if the invention is relevant for defense or atomic energy purpose, no permission shall be granted without consent of central government. Yeah, that's a obvious thing, I guess. Yeah. Now there is some piece of information that we need to know about specific patent related to biology, and so in biological, not all, I guess, in some cases you need to give your sample to certain organization, and that will be stored in the central or maybe international facilities, I guess. So first thing is there any additional requirement for filing a patent application in respect to microbiological invention? In addition to the various forms required to be filled at the time of filing the patent application, the applicant is also required to deposit the new strain of a microorganism if used in the invention disclosed in the patent specifications in a recognized depository, which assigns a registration number to the deposited microorganism before filing for patent application. This number needs to be quoted in patent application. So this is good to know. Microbiological invention, so I don't exactly know because I don't work on this field, but it's good to know. Another thing that biology patentees should know is, are there any specific instruction to inventors in respect to filing for patent application where their invention lies in biological material? The Patent Act 1970 as well as the Biological Diversity Act 2002 stipulates that the source and the geographical origin of the biological material should be clearly disclosed in the patent specification. Further, according to the provision of Section 6 of Biological Diversity Act, if the biological material used in the invention is from India, permission from National Biological Authority has to be obtained by the applicant, and the same should be submitted to the patent office before grant of patent. Another piece of information related to biological research is it essential to deposit biological material in the International Depository Authority? If the invention uses a biological material which is new, it is essential to deposit the same in the International Depository Authority (IDA) prior to the filing of application in India in order to supplement the description. The description in the specification should contain the name and the address of the International Depository Authority and the date and number of deposition of biological material. If such biological material is already known, in such case it is not essential to deposit the same. So I can see that filing a biological patent is way more complex, because I believe because most probably because unlike other patents, the patent office or the examiner may not know about the particular sample or particular new invention, so it needed to be verified, the sample needed to be verified by an independent authority or organization. So that's the way it works, I guess, in that way, so it makes sense, I guess, because unlike from let's say physics patent, in principle you can write about your patent invention in a detailed way in the patent document, and that can be reliably used for examination. But here, it's because of sample and all this thing. Yeah, I can say that material science, maybe that's also true. New material invention, who knows. but yeah, but then biology, maybe it has some other significance. That's why the arrangement is in such way. Yeah, another important thing you should know is that, especially uh, people who are doing startups and all this thing, or researchers in commercial setup like in companies and all this thing. So the government in India nowadays support this, the startups and MSMEs, and they have a certain scheme where it is like they help you through the patent application, and even the, I think, certain amount of patent fee will be refunded, something like that. So I'll just read it out for you. Yes, the government of India has formulated schemes to spark the innovative capabilities of innovators who are from MSMEs and startups. MSMEs, in case of MSMEs, a 50% fee concession is provided for MSMEs vis-a-vis large entities on patent filing fees. A scheme for facilitating startups' intellectual property protection (SIPP) has been launched for encouraging innovation and creativity for startups. Yeah, so I think it makes sense because in general in startups, the founders may be young and they may not be aware of patenting process, or even if they are aware of, but they are not very skilled or have a lot of experience in it. So that makes sense. And for effective implementation of the schemes, facilitators have been impaneled by the Consular General of Patent, Trademark and Design, CGPDTM. That's the head of all patenting jobs, I think, in India. The list of facilitators in patent and designs and trademarks is available for website of Controller General of Patent, Design and Trademarks. That means in main patent website you can find who are these facilitators. I think these are small organizations, something like that. So it's same as, I think, those incubators or something like that. So they have different roles, of course, but these are they are promoting organization. They will help you, and even they will do refunds. So it's like subsidizing, government is subsidizing. So yeah, startups are provided a rebate of 80% on patent fees as compared to the fee paid by legal entity. So that's a lot actually. 80% is a lot actually. And the question is, what is the criteria of startup? And the criteria of startup is, startup means an entity incorporated for or registered in India under the Startup India Stand Up India initiative of Government of India. Now more detail, what are the benefits provided by Government of India to startup applicants for filing patent application? Government of India provides the following benefit to startups in filing patent application in India under Scheme for Facilitating Startups Intellectual Property Protection (SIPP). An entity qualifying as startups under Stand Up India initiative of the Government of India can avail the facility of expedited examination. So this is something we discussed in the previous video. So yeah, the government reimburses the expenditure to the facilitator who assists the startup for filing and prosecuting the patent application to the extent of 10,000. Okay, so I don't know what that makes sense, because they say the 80% and then they said, okay, who knows, maybe we need to know more detail, but that's, I think 10,000 is good amount of money, but I don't know what is the total cost. Yeah, so that is all about. It's good to know about these schemes specifically related to startup, because the young people can avail this thing. Yeah. Now we'll move into the international patent and I think this will be way more interesting. And so first that some basic information. So something that you need to know about something called Budapest Treaty. This is an international treaty governing the deposition of microorganisms, cell lines, etc. in international approved authority approved by WIPO. So this is sort of an organization which is an international organization which sees the patent and trademark throughout the world, for the purpose of patent application in any country that is a party of it. And I think India is a party, of course, because of the difficulties and on occasion of virtual impossibility of reproducing a microorganism for a description of it in a patent specification. So this makes sense actually, because we are talking about why specific design or specific requirement for biology patent and all these things. So that is the reason. It is essential to deposit a strain in a culture collection center for testing and examination by others. There are many international depositories in many countries which are recognized under the Budapest Treaty. In India, I think it is called IM Tech Chandigarh is a recognized depository in India. Now, before going into PCT, which is a very interesting aspect, but in generally, when you may have the question that how am I going to apply patent for, what are the modes of filing a patent application in foreign countries as an Indian, because you may think that, okay, so this invention may be of importance in US market, so in that case you like to file in US patent and all this thing. So, but in generally, or as a important information before knowing the PCT is that first of all, since there is no worldwide patent, the applicant has to file his patent application in respective countries separately to obtain protection on his invention. The following are the routes available to the applicant to file his international application in foreign countries. And first is Paris Convention. Paris Convention for the Protection of Industrial Property, established in 1883, provided for 12 months time to file the patent application in the member countries from the date of filing of the earliest application. Patent Corporation Treaty System, PCT, is a system which allows an applicant to file in PCT contracting states means countries within 30 to 31 months from priority date instead of 12 months. Not only does the PCT enables extended time period, it also simplifies filing procedures through a simple application. The PCT system also provides for publication of application, international search, and international preliminary examination before entering national phase. So this is first of all this contracting states or contracting countries under PCT that basically belongs, most of the countries in the world belongs to this treaty. I will show you the world map. So this is the world map, and so you can see most of the countries actually belongs to this category. But important to know, I think, is that the PCT system also provides for publication of application, international search, and international preliminary examination before entering national phase. So it's not just about patent, international patent or PCT patent or patent under PCT, you just apply it. It's not that. There are several other facilities given by PCT where I believe it is international search means basically they will give sort of a report that whether your patent is valid or patentable in the specific country or not. So yeah, so we'll know about this thing in detail. So first of all, very big question, what is PCT? So PCT is an international treaty with more than 150 contracting, I think it is more than 150 now, contracting states which are bound with certain formal requirements set out in the Treaty of Regulation. The PCT makes it possible to seek patent protection for an invention simultaneously in a large number of countries by filing a single international patent application instead of filing several separate and national or regional patent application. However, granting of patent remains under the control of national or regional patent offices after the corresponding national phase application has been filed and the national phase application is assessed as per patent law of that jurisdiction. As per Indian Patent Act 1970 as amended and the Patent Rules 2003 as amended by Rule 2016, any PCT international application may be filed designating India and it shall deem to be an application if the corresponding national phase application has also been filed. So a lot of details. So there is something called national phase application, so that also you need to know. Now, more important, more detailed thing. What is the procedure of PCT? The PCT procedure includes filing, then international search, international publication, international preliminary examination, which is optional, and national phase. So these are all very important to know. File an international application with a ROIN International Patent Office or directly with International Bureau WIPO complying with the PCT formality requirement on fees. In India, PCT applications are filed at appropriate patent offices decided on the basis of territorial limit. Okay, so that I don't know, honestly speaking, what that means. Okay, so that goes to filing. So I think we can do the filing from India itself. Now, second stage is international search. An international searching authority, it's called ISA, identifies the published patent document and technical literature, that means priority art, which may have an influence on whether your invention is patentable and establishes a written opinion on your invention's potential patentability. Indian Patent Office Delhi branch performs the function of ISA on receipt of prescribed fee specified in 5th schedule of Patent Act 1970 as amended and Patent Rule 2003 as amended. So I think it means like doing the patentabilities for each 150 countries. They will do that. International publication is after expiration of 18 months from the earliest filing date. The content of your international application is disclosed to the world. So this is same as the national patent application that we discussed in the previous video. Now, international preliminary examination optional. One of the ISS on request carries out an additional patentability analysis, usually on an amended version of your application. Indian Patent Office Delhi branch performs the function of international preliminary examination on receipt of prescribed fee specified in 5th schedule of Patent Act 1970 as amended and Patent Rule 2003 as amended. So that is the I think that is it. Seems like all the tasks will be done in India, but I wonder how the individual international countries, how they are they are related here. But anyway, and the next stage is national phase. After the end of the international PCT procedure, usually at 30 to 31 months from the earliest filing date of your initial application, from which you claim priority, you start to pursue the grant of your patents directly from the national or regional patent office of countries in which you want to obtain them. Okay. After the end of the international PCT procedure, usually at 30 to 31 months from the earliest filing date of your initial application from which you claim priority, you start to pursue grant of your patent directly from the national or regional patent offices of the countries in which you want to obtain. So it seems like it the procedure is more like, you file a patent as an PCT channel, in PCT channel in India, and then you just get the patentability information that, this is okay to this will be easy to, or not easy means that this is legal to patent in, certain, maybe USA or maybe Europe, certain country in Europe and all these things. So in India, 31 months is maximum time limit to enter national phase. To enter national phase, an application corresponding to an international application is made in Form 1. Okay, so that makes sense. Okay, so that makes a lot of sense now, but I think at least a general idea we have now. Yeah, so electronically it is available. PCT application can be filed electronically with ROIN or ROIB, which accepts such filing. WIP web service helps to prepare application by automatically validating the entered data and drawing your attention to incorrectly and consistently completed parts. Yeah, so these are WIP has some website also, so that will help us. Yeah, what are the costs associated with filing and processing an international application under the PCT? And what are the costs for entering a national phase? PCT applicants generally pay 3 types of fee when they file their international application. An international filing fee, a search fee a search fee which can vary from ISA chosen, and third is a small transmittal fee which varies depending on receiving office. Refer 5th schedule of Patent Act 1970 as amended and Patent Rule 2003 as amended for fee structure for an international application designating India. Okay, now I have the question that, whether we have to make a payment to the respective different country outside India, whether we have to pay them also, I don't know. How long does the PCT process take? In most cases, up to an additional 18 months from the time you file your international patent application, or usually 30 to 31 months from the filing date of the initial patent application for which you claim priority. Okay, so claim priority is something that we will discuss later. Before starting off national phase procedure with individual patent offices and to fulfill the national requirement. Okay, this additional time can be useful for evaluating the chances of obtaining patents and exploiting invention commercially in the countries in which you plan to pursue patent protection, for assessing both the technical value of the invention and the continued need for protection in those countries. It is important to note, however, that you do not have to wait for expiration of 30 to 31 months from the earliest filing date of your patent application priority date before you enter the national phase. You can always request an early entry into the national phase. Since in national phase, each patent office is responsible for examining your application in accordance with national or regional patent laws, regulation and practices, the time required for examination and grant of a patent varies across patent offices. Okay. Okay, that makes sense, because then it will depend on the particular country where you want to get your patent. So yeah, now we'll understand what does it mean to claim priority of an earlier patent application. Generally, patent applicants who wish to protect their invention in more than one country usually first file a national or regional patent application with their national or regional patent office, and within 12 months from the filing date of that first application, they file their international application under the PCT. The effect of claiming the priority of an earlier patent application is that a patent shall not be invalidated by the reason of any act accomplished in the interval, such as another filing, the publication or sale of invention. Okay, that makes sense. Now we'll know more about international search. Can an applicant opt for Indian Patent Office as ISA or IPA for international search or PCT application? Yes, Indian Patent Office has recognized as an international searching authority and international preliminary examining authority under the PCT and started functioning from 15th October 2013. Okay, the advantages of search in Indian ISA are having access to a comprehensive collection of patent and non-patent literature that covers the PCT minimum documentation. Our integrated search platform IPATS enables one-click search throughout the vast collection of information. So this is like database for whole world, and because that will be accessible for us, not for us, but for the examiners. So yeah, so they are assuring that whatever the report will give, and that will be good actually and reliable, and you can, depending on that, you can make it your judgment that whether I will go for patent in US or any country in Europe or in China. Professionally qualified and skilled examiners are our assets. IPO has established a quality management system covering technical and administrative tasks of the office. Fully electronic processing system ensures speedy disposal and dissemination of the information on real-time basis. Fees for conducting a search under ISA or IPA are the lowest among other offices offering the same facility. Other offices means other country actually. So you will see that, of course, as you can see, PCT is like a global thing. So PCT is same in China also. So you can do a Chinese person, or you may think that as an Indian you apply in the ISA of in Chinese ISA, maybe Beijing or Shanghai or something like that, and you think that yeah, maybe it will help, but then the price will be high. That's what they say. Yeah, what are the other offices which appointed by the PCT to conduct searches? So various countries: Austria, Brazil, Canada, China, Chile, Egypt, Finland, India, Israel, Japan, Republic of Korea, Russian Federation, Spain, Sweden, Ukraine, and the United States of America, USA. So these are and European Patent Office and Nordic Patent Institute. Yeah, these are all valid ISA. They host ISAs. Now, I think this I should have discussed earlier. So, what is PCT what is international search under PCT? A PCT international search is a high quality search for the relevant patent documents and other technical literature in those languages in which most patent applications are filed: Chinese, English, German, Japanese, and in certain cases French, Korean, Russian, Spanish. The high quality of this search is assured by the standards prescribed in the PCT for documentation to be consulted, and by the qualified staffs and uniform search method of the ISS, which are all experienced patent offices. The results are published in an international search report and a written opinion of the ISA on potential patentability of your invention. So that's all about it. It's like a written report about potential patentability of your invention. That's it. What is International Search Report? The International Search Reports consist mainly of a listing of the references to published patent documents and technical journal articles which might affect the patentability of the invention disclosed in the international application. The report contains indication for each of the documents listed as to their possible relevance to the critical patentability questions of novelty and inventive steps, non-obviousness. Together with the search report, the ISA prepares a general opinion on patentability, which will give you a detailed analysis of the potential patentability of your invention. The international search report and the written opinion are sent to you by ISA. What is the value of international search report? The report enables you to evaluate your chances of obtaining patents in PCT contracting countries. An international search report which is favorable, that is, in which the document prior cited would appear not to prevent the grant of a patent, assist you to further processing of your application in those countries in which you wish to obtain protection. If a search report is unfavorable, for example, if it lists documents which challenge the novelty and or inventive steps of your invention, you have the opportunity to amend the claims in your international patent application to better distinguish your invention from these documents and have them published, or to withdraw the application before it is published. What is written opinion of International Searching Authority? For every international application, the ISA will establish in same time that it establishes the international search report a preliminary and non-binding opinion on whether the invention appeared to meet the patentability criteria in light of search report result. The written opinion, which is sent to you together with international search report, help you understand and interpret the result of search report, which specific reference to the text of your international application being of special help to your evaluating your chances of obtaining a patent. The written opinion is made available to the public in same time as the application. So that is all about international patent application. Now we will enter into some detail about the international publication also. Now we will go into more detail of international patenting. As we can see that it doesn't really, it's not like the normal national patent that your patent will be granted or something like that. It's more like in the preliminary stage where it automatically prepares you for filing the same patent in specific countries. So the first question is, what is the international preliminary examination? International preliminary examination. I think let's start with this. What does international publication under PCT consist of? WIPO publishes the international application shortly after the expiration of 18 months from the priority date, together with international search report. PCT international application are published online on Patent Scope, a powerful, fully searchable database with flexible multilingual interfaces and translation tools to assist users and public in understanding content of published application. What is the international preliminary examination? International preliminary examination is a second evaluation of the potential patentability of the invention using the same standards on which the written opinion of ISA was based. If you wish to make amendment to your international application in order to overcome document identified in the international search report and conclusion made in the written opinion of the ISA, international preliminary examination provides the only possibility to actively participate in the examination process and potentially influence the findings of examiner before entering the national phase. You can submit amendments and arguments are entitled to an interview with the examiner. At the end of the procedure, an international preliminary report on patentability will be issued. International preliminary examining authority which carry out the international preliminary examination are the ISAs mentioned above. for a given PCT application, there may be one or more competent IPES. Your receiving office can supply detail for you may consult the PCT applicant's guide and the PCT newsletter. Now let's consider national phase. How do I enter national phase? That means how do I now from PCT you get the report and all this thing. Now for individual countries, how I get the patent. So it is only after you have decided whether in respect to which state you wish to proceed further with your international application, you must fulfill the requirement for entry into the national phase. These requirements include paying national fees. That means national not means India, but which country you are going for, and in some cases filing translations of the application. These steps must be taken in relation to the majority of PCT contracting states patent offices before the end date of 30th or 31st month of the priority date. There may also be other requirements in connection with the entry into the national phase. For example, appointment of local agents. More general information on national phase entry can be found in PCT applicants guide national phase, and specific information concerning fees and national requirements can be found in national chapters for each PCT contracting state in the same guide. What happens to my application in national phase? Once you have entered national phase, the national or regional patent offices concerned begin the process of determining whether they will grant you a patent. Any examination which these offices may undertake should be made easier by the PCT International Search Report and the written opinion, and even more by an international preliminary examination report. So there are three things PCT will provide: an international search report, the written opinion, and international preliminary examination report. So if you have that, then that will be easy for the regional offices. I mean, regional means the national offices, like means if you are applying for Japanese patent, then it will be easy for them to grant you or not grant you, making the decision. Now finally, I'll just touch upon a broader issue, like what are the advantage of patent corporation treaty, PCT. The PCT system has many advantages for an applicant, for patent offices, and for the general public. You have up to 18 months more than if you had not used the PCT to reflect the desirability of the seeking protection in foreign countries, to appoint local patent agents in each foreign country to prepare the necessary translation, and to pay national fee. Because this is important, because I believe that in Japan basically they don't have the English option, so you have to, then in that case you have to hire Japanese people, and then they will do that. I mean, not you as a researcher, but your organization. Yeah, so these are a very broad thing. I believe when your patent is very valuable and seen to be very valuable, then only these will be done. But it is very important, I mean, good to know these things. If your international application is in the form prescribed by the PCT, it cannot be rejected on formal grounds by any PCT contracting state of patent office during the national phase of the processing of application. The international search report and the written opinion contain important information about the potential patentability of invention, providing a strong basis for you to make business decision about how to proceed. So this is important, business decision. That means I think they are talking about, this kind of thing are not just for a university perspective, but let's say big organizing company, maybe they want to file a patent worldwide, maybe that is in those cases, these are very much true. Like, Google, maybe, or Microsoft. So anyway, you have the possibility during the optional international preliminary examination to amend the international application, enter into dialogue with the examiner to fully argue your case, and put the application in order before processing by the various national patent offices. Search and examination work of patent offices in national phase can be considerably reduced due to the international research report, the written opinion, and where applicable, the international preliminary report on patentability that accompany the international publication. You may be able to fast track examination procedure in national phase in contracting states that have PCT, patent prosecution highway, PCT PPH or agreement or similar agreements. Since each international application is published together with an international search report, third parties are in a better position to evaluate the potential patentability of the claimed invention. Yeah, so there are other things also. So that's more or less the summarization of importance of PCT. I believe that is very good option, and I believe these are more or less important for big organization. Even for universities, I don't think they do this kind of thing, like worldwide patent or something like that, or maybe they do that, who knows that. So but I think it's more true for the big businesses. So that's all about all the detail I want to give it to you. So that's it. So this is the web link from where I downloaded this document on which I'm making this particular video, and this is basically from the Indian Patent Office website, I think. And this is the end of this part 2 of the video, about Indian patent, and also how you can get international patent through Indian patent offices and all this thing. So this will be the end of the the series. So please, if you like the video, please like, share and subscribe. So see you in the next week.